So I'll go for the first. Significant changes are regarding the importation and movement of contaminated soils. Over the last several years, there's been a lot of positive developments, literally, in industrial real estate along Doremus Avenue and other low-lying areas where property developers are able to import hundreds of thousands of tons of tainted soils so long as they meet certain requirements. And in one instance, one of our clients, you're always able to backfill an excavation during a remediation with soils that are not necessarily clean as long as they meet certain conditions. They call it the 75% like on like. You're allowed to bring in contaminated soils provided they're similar in nature to what they'll be sitting within. So if you have historic fill material, you excavate out contamination, you can bring back in similar historic fill material as backfilled. Up until recently, you were also able to, without getting approval from the DEP, so long as your LSRP created the right paperwork, you could bring in additional volumes of the same contaminated soil all the way up to the floodplain. And in certain situations, we're able to bring in 6-8 feet of soil across like an 8-acre property. When if you think about it, that's a dramatic savings to the property owner. Now, under this change, the DEP they'll still potentially approve it, but now the LSRP does not have pre-approval for that activity. They actually have to go to the DEP and get approval under a BUD. So that's one major change. Under neither scenario were you able to bring in fill material above the floodplain, but this is a lot of soil, and it's a very huge economic impact when it matters.
Mike, for a quick question, just for everyone's benefit, what is a BUD?
It's a beneficial use determination. It's when you go to the DEP and ask them for permission to bring in fill material that isn't certified clean. And the other change, which I guess is for the positive, they have new guidance called the capping of volatile contaminants for the impact to groundwater pathway. And the short story there is, most people in the room are familiar with deed notices and being able to leave contamination in place at a property. Normally that is, due to discovering historic fill material and leaving contaminants that typically include heavy metals and base neutral semi-volatile organic compounds that are just that you're normally used to doing that, but traditionally you're not allowed to leave contaminants including benzene and gasoline constituents and other volatile organic contaminants above the water table at all, above the standards. And the problem is with the volatile organics, you have residential standards and non-residential standards that are up in the parts per million. For example, TCE is well over 1,000 parts per billion as far as the residential, non-residential standards, but the impact to groundwater standard is 5 parts per billion. So for the last several years at several sites around the state, people are chasing around soils above the groundwater table at these trace concentrations. And now under the new guidance, you can leave these contaminants in place provided you get approval from the DEP under RAP and your LSRP satisfies certain conditions that the groundwater is not being continued to be impacted by those contaminated soils, and there's certain vapor testing requirements. But provided you meet those requirements, you can deed notice those VOC contaminated soils, which again is a big deal. We just finished one cleanup on Doremus where we probably had to move 8,000 to 10,000 tons of soil that really was not causing a problem to the groundwater. We had plenty of wells to confirm that. It just ultimately was backfilled and repaved and used for container storage. So in that situation alone, they would have saved probably $1 million in soil movement. Yeah, there are two changes in underground storage tanks. One in the unregulated heating oil storage tank regulations, which actually changed its name to Heating Oil Tank Systems, HOTS. It's really not worth spending too much time on it, except to say that one significant change that was codified was that they added the term small quantity exemption. So at a residential property, you can leave in place up to 15 cubic yards of contaminated soil without getting a deed notice. So it's just making the process and approval process a little bit easier for the homeowner is probably all that needs to be said on that side of things. On the regulated underground storage tank system, rules, really nothing significant changed. They added some language where the LSRP is required to issue an RAO when they perform a site investigation with the suspected leaking underground storage tank. That, you know, in practice, that was always happening. I think that they're talking about certain specific scenarios where LSRPs were evaluating tanks that were thought to be leaking by others. I don't know. It's not that significant of a change, so I would leave it there. Several have sat on several workshops recently about the proposed changes that are coming out. One thing that is very clear is that the DEP personnel in charge seem to be very happy with the LSRP system. They're not looking to get rid of it. That was always a fear that at some point we're going to go back to the old DEP with case managers. That doesn't seem to be anywhere near anyone's thought process. But to Dennis's point, they are, through remedial action permit approvals and through the requirements for BUDs and through some, you know, where they're able to not second guess the LSRP, but require the LSRP to come in for an approval. There's certain administrative changes that are being talked about, but I wouldn't confuse it with, you know, Governor Murphy's looking to get rid of the LSRP system altogether and hire 5,000 new DEP case managers and change the world. I think it's just they're looking to just tighten the screws a little bit on kind of in their mind, reining in the LSRPs a little bit. That's probably too strong a language, but please participate in this part of the conversation, because I think this is the most relevant and significant to the commercial real estate community. Anybody working on deals, want to pay attention to what the DEP is thinking about doing. Like Dennis said, that there's been several workshops that many of us at this table and people around the room have participated on, where the DEP and the LSRP board has been very good at kind of inviting members of stakeholder groups. I participated on behalf of NIOP, the National Association of Industrial and Office Properties. There were representatives from the LSRP Association itself, which is apart from the LSRP board. The LSRP board is I think, a dozen specific people, most of which are LSRPs, and some of which are DEP administrative type people. But the LSRP Association is the group that represents all 680 or so LSRPs. Also at the table were people representing the New Jersey State Chamber of Commerce, the New Jersey Builders Association, and SRRA, which is basically like large companies, big oil, that are performing big remediations. Generally speaking, in each of the workshops that I participated on, like 4 out of the 7, there was unity among the trade groups, including the LSRP Association. Most of the changes and workshops that I sat in on were administrative. The DEP and the board's recommendations were housekeeping and actually made sense, but some of them were very sensitive. And I'd say that the one that I'm focused on, that most of you are involved in commercial real estate transactions where the obligation to report a discharge, the discovery of contamination to the DEP, falls on the property owner. And if the property owner is not aware that data exists, then there's no obligation for reporting that in most instances. So a buyer, under due diligence, can and often does inspect the property and move on to a phase 2 or a site investigation and collect soil samples or groundwater samples or other samples, send them to a laboratory, get results, and if the results indicate that there's contamination above certain standards, DEP standards, the buyer is not obligated to report anything to the DEP. Third parties in general aren't obligated to report anything. But once that information makes its way, if it makes its way to the property owner, at that time, then the property owner has to report the incident. So most of you are involved in this industry, and it's common for the brokers and the attorneys for the seller to say, listen, if you're afraid about selling your property, you're afraid about what might be discovered, and if this person's going to find potentially a $1.5 million problem at your $500,000 property, you're afraid that they're going to run away, report something to the DEP, and leave you holding the bag with this problem. And so in a very positive way, I believe, for the environment, for ultimately cleanups, the state of New Jersey has allowed for the practice that you're all used to, accustomed to, where the buyers and their consultants can enter into be restricted by a confidentiality agreement where they're not allowed to disclose anything, especially to the seller and the property owner. in all sorts of different, and of course the DEP. And that's been the practice in this state for the last 40 years. Interestingly, most of these changes that are proposed are tweaking of, how do we continue to regulate and protect the environment under this new LSRP system? We got to make some changes to SRRA because it was the intent all along for these procedures to be followed. But this change in the proposed change in the discharge reporting obligations is a wholesale change to practice that long predated LSRP. It's just interesting that this language is being slipped in today in 2018 about that's something that will cause, I think, harm to the environment. I think that there's a lot of customers, a lot of property owners. It's the little old man that's been sitting on his property for 40 years thinking that he has buried drums, thinking he's got some problem because there's some anecdotal story in the neighborhood that there's some blue soil, in the backyard. Most of us that are practitioners, we know that's, you kind of guide some of these property owners to the table, list their properties. At the end of the day, I've been in this business for 30 years in New Jersey, and we've signed confidentiality agreements. We've been restricted under these transaction requirements, and I don't think there's one instance where we've discovered dramatic contamination and kept the data away from the seller and ran away from the property along with the buyer. I mean, normally we sign confidentiality agreements, we proceed, we do a phase 2, we find nothing, or we find something that represents a problem that comes nowhere near challenging the sale value of the property. Really, unless there's a couple specific instances, we don't have any experiences over 30 years where the deal didn't happen. And even in some deals where buyers turn away, they're probably turning away for reasons other than contamination we discovered. And think of the hypothetical scenario where somebody finds a $2 million problem through due diligence, and they turn around and run away from the property and don't show the data to anybody. Well, that seller learned something, and that seller learned something that he might not have learned if he thought that he would be giving up the ability to not report a discharge. He probably would not have let that buyer in the property in the first place. So I think that the proposed language, you can see where it comes from. From the regulator standpoint, they look at this sea of 685 responsible, intelligent LSRPs, and they're not property owners. They're not the little old man sitting on his property for 40 years and they're saying, hey, you guys know better. When you find some contamination above the standards, you should be reporting the discharge. So if you look at it from that perspective, you see why somebody would want to add that language to the regulation. But that's not what it's all about. It's about the property owner's rights, and whether or not forcing the reporting of a discharge will actually prevent property owners and sellers from actually listing their properties in the first place out of fear of letting people on that will generate data that will harm them if the contamination is thought to be more expensive to remediate than the sale value of the property. There was initially the language was that the buyer himself would be required to report directly to the DEP, and after some backlash, they changed it so that the buyer would be obligated to report the information to the seller to trigger the seller's requirement to report to the DEP. But that's, that doesn't really change. That protects like a rogue buyer, or there's scenarios that's helpful, that change. But the concept of forcing the seller to receive information and rat himself out to the DEP immediately is the issue, and there's really no middle ground on it. It's either required or it's not. But I'll say that I think the background of sellers and their attorneys limiting the buyers from having LSRPs perform due diligence, I think it was based on the initial language in LSRP rules was that the LSRP was viewed as the agent of the state and they would report all discharges if they got to the property. The reality is that an LSRP is not required. Even if I walk onto a property on behalf of a buyer and I review data and I see that there was a discharge, I'm not obligated to report a discharge on behalf of the buyer or on behalf of myself. It's only if I see a very specific problem, the immediate environmental concern, which is I think that's fair for the lawyers to insert language and protect the seller, But people should be aware that that's the very specific finite issue. I think a lot of the real estate community is under the impression that LSRPs have to report anything, and it's just not the case. So sometimes you might be voluntarily giving up your right to have the smart guy, so to speak, evaluating a property, and then allowing yourself to have this restriction to have non-LSRPs inspect the property under the thought that it's fair enough that guy would have to report any problem, and this guy doesn't. But that's not the case. I mean, I think the protection of the IEC is certainly something worth discussing, but I don't think that's what people are thinking when they're agreeing to these terms.
Right. And before Dennis comments, just what are the examples of an IEC, an immediate environmental concern?
It's just something I'll tell you what it's not. It's not like substantial levels of petroleum in a soil sample. It's not a leaking underground storage tank. It's not even certain obvious contamination indicators. It's something that represents an immediate environmental concern to the health, free product, a vapor issue. There's not too many IECs that are discovered during a phase 1 assessment. Yeah, it's kind of interesting. It's you sit at the table and you realize that people come into a room with one set of ideas, and they weren't necessarily viewing it from the other person's perspective. So the trade groups and people representing property owners are looking at it one way, where we have LSRPs and they do the investigations and they define what the remediation and abatement is necessary, and then we follow their advice, but together with counsel and economic concerns. And the back and forth that the client and the LSRP and the attorney have had before and after LSRP is most of us would believe is healthy, and that's part of reality of approaching a cleanup. This proposed language, and it was clear in the workshops, that the drafters of the language, really had some feeling that the LSRP should never be concerned with the financial interests of the client, and actually should be precluded from being concerned with the financial interests of the client. It was very interesting. It was just it was something that you would think was not debatable. Some on the other side think that it's not debatable in 180 degrees vantage point. So it was just, ultimately though, as Dennis said before, and they're not concerned with the 99.9% of instances of transactions and LSRPs and property owners. They trust the masses, but they seem to be concerned with one or two examples over the last 20 years where an LSRP decided to submit a report and defended him or herself by saying, well, my client couldn't afford it and he told me to send this document instead of the one I would have sent in. And that's just not the reason to change law. It's just an interesting topic. I mean, but that's kind of the example of some of the proposed language changes and where they come from. Yeah, just to kick off one example, but I would say that really an LSRP case study could be any SRRA case, any property transaction involving a phase 1 even is something that where if we ultimately take a sample and open up a case number or address an existing case number is a case study worth discussing. So if you have any examples you'd like to talk about, please, we can open up to the room. But just focusing on one where we worked together with, actually initially we did not work together with Dennis. I represented through some of the brokers in this room, coordinated a transaction where the Reichold chemical plant in Newark, it's an 11-acre site right on the river on Doremus Avenue, actually had an interesting history. It had a chemical factory there for the last 30 years, and before that there was another chemical factory that had its own SRRA case. So there was a 25-year-old SRRA case that was not completed, had at least a dozen areas of concern under dispute between the subsequent operator who had its own SRRA case. So we had two SRRA cases that were not completed, involving probably collectively over 150 areas of environmental concern. by the time this transaction occurred, there was about a half dozen areas of concern to be addressed by one party and another half dozen areas of concern to be addressed by the other. But they were in dispute, and the cleanup was not happening for years, if not decades. And through the LSRP system and through the work of the buyer and the seller, this transaction took place with the property buyer first purchasing and stepping into the shoes of Reichhold and taking on responsibility for their ISRA case and completing their, addressing their open issues, and then negotiating with the former operator and stepping into their shoes to complete their ISRA case and their areas of concern that were outstanding, and then working together, because this deal was set up in large part to accommodate the market's need for a pilot refueling station and some truck storage to meet the recent demand for industrial real estate and trucking, et cetera. And so the remediation was performed just in advance of Dennis's client, who's a large refueling station for trucks. So that right now, if you look at the pictures on your table, we've turned something very rapidly. In less than a year, we had a chemical company that was out of service, falling apart, state of disrepair, was demolished. We remediated more than 8,000 tons of contaminated soil and addressing groundwater then and now through a CEA. And we have already in service for over 6 months a up and running gasoline service station to feed the trucking industry that's been booming during the last few years under this industrial real estate Amazon existence that's here to stay. So I think it's a great visual of a remediation that was necessary, that was being avoided not avoided, but was being impeded for a few decades. And now, because we had the ability to have multiple LSRPs sit down at conference room tables, and we had LSRPs from 4 different parties, minimally, actually, plus some input from additional LSRPs, always around a boardroom together with the attorneys from the various interested parties, but had agreement and were able to move on from one stage to the next, all in short order. I mean, these were discussions and agreements that would come together in days, and remediation would take weeks by the area, an area of concern, whether it's soil, groundwater, et cetera. If I could ask if Dennis, you could speak to the tenants' input or their role. Yeah, well, I'd say in this example, there were multiple LSRPs representing each respective entity, but there was LSRPs for the one ISRA case, Reichhold, and for the other ISRA case, Textron. But ultimately, when we took over each of those cases, then I replaced those respective LSRPs. So we never had simultaneous LSRPs for ongoing, other than those 2 cases for a while. But yeah, the standard, I would say almost the standard in the state is if you have different responsible parties, like you could have an Exxon station that operated in the 1980s and then a Sunoco station that operated in the 1990s at the same property, more often than not, you will have a separate LSRP representing each entity for those separate tanks. And all sorts of different examples of one client, one responsible party may have one LSRP addressing a pretty straightforward AOC like an underground storage tank, but then having a separate LSRP altogether working on some substantial remediation of groundwater. You might have like a local firm working on one AOC and a national firm working on something that's sensitive, that's involving potential litigation. So short answer is yes, there's multiple properties with multiple LSRPs either working for the same entity or working for separate entities. And you clearly see that if you have separate responsible parties, they're going to have their own LSRPs. Yes and no. The bulk of the fill material was certified clean fill. There was some importation of asphalt millings, which is its own, topic. So the short answer is no. There wasn't a 75% like on like of any significance.
So follow up to what you were talking about, Dennis, and this came up actually in the court that I was
question is, what responsibility or obligation do two LSRPs have to one another to work together or share information?
You know, I would say generally speaking, the issues or the concerns one would have are really addressed with the existing law. I mean, the LSRP has a responsibility to his customer, the responsible party. And if I'm working on an underground storage tank area of concern, but I discover TCE in a sample that I pull because I'm looking for volatile organic compounds related to the gasoline that I'm dealing with, I have an obligation to make sure that that TCE has already been reported, and if it has been, it's associated with another AOC being addressed by a different LSRP, then I get that information to my customer and it gets back to that LSRP. So I can't imagine a scenario where an LSRP that is working on AOC 1 is just sitting on data because it doesn't relate to AOC 1. That's not how it happens in reality, and it's already addressed by law that property owner is required to make sure it gets the information from you that you develop. So I don't really have a for instance where the LSRP would be sitting on information or not transmitting it to others within the body of the property without being, you know. And I'll say, I would even say relative to the people in this room, the one thing that can be improved of all things under the LSRP system is the communication between LSRPs and the timing of transmitting data to either this department or to your client. I mean, the notion that you can have multiple LSRPs at the same property, but then have LSRPs say to each other like, oh, you got to get my data through an OPR inquiry, and that would only give you access to data that was generated a year ago and everything else is just sitting on their desk. That could need some improvement. I would say more on a housekeeping and maybe add some language as far as timeframes and sharing information, et cetera. Not so much multiple LSRPs and one LSRP's got to speak for the entire property. That, I think, has a lot of challenges because you don't want to start putting contractual obligations from one LSRP to the other and all the various liability issues and just the additional costs that the property owner would have by having layers of people reporting to each other. But yes, there are communication issues that I think that most of us would say could be improved. And additionally, just the DEP's online system of identifying the LSRPs at a given property, just the data miner system could use some tweaking. You know, just follow up on one comment you had, Chris, that if your consultant does an assessment and even a remediation and he's subject to a 3-year audit period, just because your LSRP issued an RAO, even entire site RAO, if you're looking to tear down the building and rip up the skin of the property and redevelop it and move a lot of soils, just because your consultant didn't discover any underground storage tanks or didn't discover groundwater contamination or some buried issue, it doesn't mean that he's negligent if when you rip up the entire property and find things that you can sue the consultant and tap his insurance policy. More often than not, the insurance coverage, other than just providing legal defense, we have examples that we've been overseeing on others that the consultant was not, arguably not, at fault, not negligent, but when these wholesale excavations happen, they turn over the property. Yeah. There are a lot of things that are not discoverable. When you look through every single aerial photograph, every Sanborn map, the consultant can clearly be following the standard of care, but you're left being the buyer and developer of that property, and the 10 grand per year or whatever the policy costs are turns, when you look back on it, is a good deal. But just to follow up, and Chip, it's a great question. I think that not just like how much insurance should I carry or you carry, but I think the real estate community, the principals of the transaction, and particularly the lawyers, it's something that is asked often, but it's not asked on every deal. Like, how much insurance do you have, LSRP? And I think it's not just considering getting PLL for the buyer. It's also also have a clause in the contract that says, hey, LSRP, before we hire you, you're going to have maintain that insurance coverage, and it's going to be at least X. And I think that, I don't know whether the deal makers, I've never really heard anybody have any anecdotal multiplier of the value of the property transaction versus the coverage of the E&O policy on the LSRP or the phase one provider. But I would think that should be some, you certainly want to have more than $1 million coverage on your consultant, and probably, this day and age, at least 5, I would say.